Okay.
The broadcast is now starting. All
Okay.
attendees are in listen-only mode.
All right, now start.
Okay, on
Okay.
Facebook.
Assalamualaikum and good morning, ladies and gentlemen. We are about to begin shortly, and it would be great if we could ensure there are no distractions. Working from home in this is challenging, and this session will be indeed a one of a kind. We will be announcing the guest of honor shortly. Thank you. Okay, we started. Nice. Okay. Immediately picking F1105. No. Alright, I can replace that. Okay, let's start today. All right. Assalamualaikum and good morning. Yang berbahagia Datuk Dr. Engineer Andy Kahesio, Co-Chair of PEMUDAH and Vice President of Federation of Malaysian Manufacturers. Our panelists, Yang Berbahagia Datuk Chang Kim Long, Honorary Secretary General of National House Buyers Association. Our panelists, Yang Berbahagia Datuk Roger Tan, the Chairman of Conveyancing Practice Committee, Bar Council of Malaysia, and President of Strata Management Tribunal. And our panelist, Surveyor Wong Kok Soo, Technical Advisor of Association of Valuers, Property Managers and Estate Agent in Private Sector Malaysia, PEPS Malaysia. Distinguished guests, ladies and gentlemen, Assalamualaikum, good morning and salam sejahtera. On behalf of MPC and PEMUDAH, I would like to extend a very warm welcome to all of you to PEMUDAH Webinar Series 2, Adequacy of Our Law on Stratified Properties During and Post MCO. My name is Samsur Amanya, and I will be your moderator for the webinar session today. First, I would like to thank all the attendees that registered for today's PEMUDAH Webinar Series 2, Adequacy for Our Law on Stratified Properties During and Post MCO. And due to the overwhelming response for those who did not manage to register on time, we are also streamed live at PEMUDAH Facebook page of PEMUDAH Malaysia. I would like to say for all the attendees on PEMUDAH live page right now, there are 200 over of you now. Good morning and very welcome to today's session. So, before commencing the opening ceremony, allow me to introduce our guest of honor, Yang Berbahagia Datuk Dr. Engineer Andy Xiao Kian Ho. Natu Xiao Jian Hao 博士. Dr. Andy Xiao is the co-chair of PEMUDAH with the Chief Secretary of Government of Malaysia, the Special Task Force to improve the government delivery systems. He served as chairman, senior advisor, and directors in various organizations. He has worked in various MNC in Malaysia, Indonesia, and Asia South in various senior management and directors positions. He specializes in profit improvement and turnaround management. He also served as Vice President of the Malaysia Federation Malaysian Manufacturers, FMM, and Chairman of the FMM Logistics Committee. He is the Chairman of the Malaysian National Shippers Council. He was Vice President and now a council member of the Institution Engineers Malaysia, IEM. He is also Head of Commissioner of ASEAN Engineering Register. Dr. Andy Xiao is the advisor under manufacturing and operation to Top Glove Syndrome Berhad, and it is on the Board of Trustees of Top Glove Foundation. He is a board member of Sirim Berhad and also Sirim QAS International, Sirim Tech Venture, and Chairman of Sirim Standards and Training Services. He graduated in production engineering from University of Hertfordshire, UK. He also obtained an MBA in General Management from the University of Hull, UK. Attended London Business School on Strategic Management and attended IMD Switzerland on Change Management. He received an Honorary Doctor of Science from the University of Hertfordshire, UK, and Honorary Fellow of ASEAN Fellow Engineers Organization. He is also a registered professional engineer in mechanical engineering. He is a Fellow of the Institution of Engineers Malaysia, a Fellow of the Institution of Engineering and Technology UK, a Fellow of the Academy of Science Malaysia, and a member of the Malaysian Institute of Management. Ladies and gentlemen, please welcome Yang Berbahagia Datuk Dr. Engineer Andy Xiao Kian Ho, Co-Chairman of PEMUDAH, to deliver his opening remarks. Dr. Andy, please.
Thank you very much, Mr. Moderator, Tuan Haji Samsul Amanya. Good morning, Yang Berbahagia Tan Sri, Dato', fellow distinguished speakers, webinar participants, ladies and gentlemen. Welcome to the PEMUDAH second webinar in the series, which is entitled Adequacy of Our Laws on Stratified Properties During and Post MCO. My name is Andy Siao, co-chair of PEMUDAH, the special task force to facilitate business, which was established 13 years ago to bridge the gap between the private and public sectors by addressing business issues and providing pertinent recommendations to facilitate business. Now, the collaboration between PEMUDAH's public and private sector members assist policymakers in making sound and workable solutions. Our government's movement's control order MCO is a countermeasure to contain the spread of the COVID-19 virus pandemic. Now, this virus is impacting on all sectors of the economy and on the everyday lives of our Malaysians in an unprecedented, catastrophic, and systematic way. Non-essential businesses have to cease operation. Supply chains in so many industries are being disrupted. Financial losses and losses of business opportunities are also mounting. The education of our children are also slightly delayed. These losses and inconveniences are an unavoidable price that has to be paid by all Malaysians in our fight against the virus. Now, PEMUDAH is reaching out to the Malaysian public through a series of webinars to share practical solutions and tips on how to deal with issues arising from the MCO. Stay at home. Time will then be more productive. Now, our webinar today will surface and examine the key issues that affect stratified properties, living and management, especially during the post-COVID MCO. Now, the existing laws on stratified properties and stimulate discussion on the adequacy of such laws and whether and how to fill in any lacuna in the legislation for stratified properties. Today, we are very honored to have with us our panel of distinguished experts in legal conveyancing, strata management, professional property valuation and management, and estate agencies, as well as the intricacies of house purchasing. They are none other than Yang Bahagia Datuk Chang Kim Long, Honorary Secretary General of the National House Buyer Association, another good friend of mine, Yang Bahagia Datuk Roger Tan, Senior Lawyer and Chairman of Conveyancing Practice Committee, Malaysian Bar Council, and President of the Strata Management and Tribunal, Surveyor Wong Kok Su, Technical Advisor to the Association of Valuers, Property Managers and Estate Agents in Private Sectors. Today also to our moderator of the session, Tuan Haji Samsul Rahman, an architect by profession and a Malaysian Productivity Corporation associate. With that, ladies and gentlemen, I wish you all a fruitful session. Be sure to look out for the next PEMUDAH webinar session in the series. Stay home, stay safe, and also stay productive. Thank you.
Thank you, Yang Berbahagia Datuk Dr. Engineer Andy Kensio, the co-chair of PEMUDAH. As what Dr. Andy was mentioned just now, we are going to touch on three major areas for today's webinar. Okay, just let me go through the agenda with every one of you shortly right now. We just had our opening remarks by Yang Berbahagia Dr. Andy Sio. First, we're going to have our first panelist, will be by Yang Berbahagia Datuk Chang Kim Long. He will be touching on the absence of Housing Development Regulation 11.3 and force majeure clause in the standard SPA. Can Section 2.2 in Housing Development Act be invoked? What is the way forward? And following by Yang Berbahagia Datuk Roger Tan, he will be then talking on the legal issues related to stratified properties during and post MCO. Malaysian too needs a COVID-19 bill. And following with our third panelist, Severio Wong Kok Su. Severio Wong will be talking about on the issues related to the management and maintenance of strata buildings during the MCO period. And last, it will be a question and answer section. And as we have both the webinar as well as Facebook Live today, so we will be given the priority for those who have registered that in webinar. So we will be prioritize all the questions in webinar, that only the Facebook Live, the question from Facebook Live. Okay, just let me bring you through the entire whole event of MCO. On the 16th of March, Prime Minister declared nationwide movement control order to begin on 18 March 2020 under Prevention and Control of Infectious Disease Act 1988 and Police Act 1967. Then our first MCO starts from 18th of March until 31st of March. It lasts for 2 weeks. Following the MCO phase 2 from 1st of April until 14th April, that is a cumulative of 4 weeks. On the 10th of April, MITI issued a list of additional sectors allowed to apply for operating permit to bolster the economy post-COVID-19. Applications from 13th April 2020. And we have our MCO phase 3 from 15th April to 28th April. So it will have been a cumulative of 6 weeks by then. And on the 22nd of April, 1,856 construction projects out of 19,000 applications were approved to restart work as announced by the Senior Minister of Works. That is 5 weeks from the start of MCO. And we just had last week that MCO phase 4 from actually from tomorrow, 29 April to 12th of April. So it will be a cumulative of 8 weeks of MCO. And then following week in May this year, we have our Hari Raya 3-day holiday, which is from the 24th to 26th of May. So if we have going to have an MCO phase 5 from 13 May to 26 May, it's probably going to have a cumulative of 10 weeks of MCO. So 10 weeks, that is going to be a long time for no handover and no construction works on site. So perhaps let's start with a brief introduction on our first panelist, Yang Berbahagia Datuk Chang Kim Long. Yang Berbahagia Datuk Chang Kim Long is a founder and holds the position of the Honorary Secretary General of National House Buyer Association, in short HBA, which is a voluntary, non-profit, non-political organization manned by volunteers members of various professions. The organization operates purely on volunteers, workers, benevolence, and continues to be until today. Over the years, HBA has, through his leadership, become an authority on house buyers issue, and HBA views are often sought after in the housing industry. He is presently a permanent member of Special Task Force for Revival of Abandoned Housing Project and an active member of the PEMUDAH Subcommittee on Real Property and Focus Group on dealing with construction permits. He sits in several working committees on the amendments to the Housing Development and Strata laws at the Ministry of Housing and Local Government and Ministry of Water, Land and Natural Resources. Dr. Chang Kim Long has served the current Selangor State Government as Town Councillor for Majlis Perbandaran Subanjaya on an NGO and professional quota for 3 terms from 2008, 2010, and 2012 to 2003, and the current 2016 to 2018, and sits on several committees that relates to his expertise. He is also a columnist for several newspapers, online medias, magazine, and a voice for the house buying public and strata community. Welcome, Dr. Chang Kim Long.
Thank you.
Good morning, Dato. How are you today? I hope you're well.
Yeah, always well.
Okay, Dato, it's very in the lifetime, not everybody can buy a lot of houses. Most of us, we can only in our own lifetime can only buy one house. And looking at the MCO, that it may be going to accumulate for 10 weeks until Hari Raya. So all the money has gone. So delay in handing over for the vacant possession in the housing development projects due to MCO is going to be a major issue. And looking at the previous webinar on the series 1, so the previous developer, the developers and some of the professionals are all talking about extension of time, which is also the EOT. So in your view, what do you mean by extension of time? Dato', over to you.
Okay, thank you very much. Well, the previous group of webinar participants talk about they were grieving and mourning about the EOTs that is no longer applicable in the market anymore. That concept of EOT is no longer applicable. Now, what is EOT in the first place? Well, effectively, it means breaking a developer's contract and delays in completing construction is excused, and the house buyers cannot claim for LAD, that's liquidated ascertained damages, for the period EOT was granted by the Minister of Housing via his housing controller. Now, rights and protection given by Parliament is extinguished by the housing controller with a stroke of a pen. Now, that's what it means. The developer who commits the breach stand to make hundreds of millions of dollars from not paying LAD at the pain and sufferings of house buyers. That's what it means. Now, we are talking about a group of house buyers who have suffered losses due to the delay in the completion of their house by the developer, by the very Ministry of Housing that is supposed to protect them, but they sign away the rights in favor of developer. We are talking about such rights and remedies taken away from the house buyers for the benefit of those corporate developers who caused them the loss and sufferings. Now, under the same standard sale and purchase agreement between house buyers and developers, a developer must complete a landed property within 24 months and a stratified property within 36 months, failing which they have to pay compensation called LAD at 10% of the purchase price. Now, because the developer could not finish in time, they ran over to the minister and the housing controller and managed to get EOT for additional 1 year. It means during that 1 year, compensation did not be paid by the developer to the house buyers. Now, that is utterly unfair. No reasonable-minded person, let alone the housing minister and those under his charge, can possibly imagine that the power given under Housing Development Regulations 11.3 is meant to be used against house buyers, let alone blatantly and unilaterally taken away rights which are expressly given to them by Parliament, rights that are entrenched in the sale and purchase agreement. Now, I find that if discretionary power are not exercised in prudence or prudently, right, it's time this power is to be removed, or perhaps the minister replaced. Now, I'm a strong believer of not having discretionary power in our law. Laws must be made and drawn up in no uncertainty. If the completion date required for a 30-story multi-level development, and depending on its complexity, be stated at 48 months, say so. Let's come up with a new set of S&P agreement instead of changing from 36 to become 48. Don't attempt to seek EOT, hence allowing the minister and those under his charge to have discretionary power to grant or to reject. Now, perhaps it is time we have a new prescribed sale and purchase agreement. We have a new set of Schedule H1 for 48 months, Schedule H2 for 54 months, in addition to the existing Schedule H, which is 36 months. It now depends on what's the threshold to get 48 months completion date. Should it be more than 30 stories or depending on the complexity of a project? Now, do not forget, be mindful, by granting unfettered discretionary power in our law, it ordinarily means that there is a various alternative that can be accosted and done in bad faith. mollify it in its narrowest sense. This discretionary power thing will confer wide power to ministers, to ministry people, and it smells arbitrary power aligned to patronage. Big developers have big clout, while small developers have got none. We must do away with discretionary power, and which may lead to incorrect decisions with improper motives, biasness, or under the influence of politicians, and it may be abused. I qualified my words, I say it may be abused. I will not go beyond that. Thank you.
Okay, thank you, Dr. Chang. Okay, Dato, you were mentioning about Housing Development Control and Licensing Regulation 1989-11(3). It says where the controller is satisfied that owing to special circumstances or hardship or necessity compliance with any of the provision in the contract of sales is impracticable or unnecessary, he may, by a certificate in writing, waive or modify such provision, provided that no such waiver or modification shall be approved if such application is made after the expiry of time stipulated of the handing over of vacant possession under the contract of sales or after the validity of any extension of time, if any, granted by the controller. So I'm just having some question here. It says, since the housing controller has the power to waive or modify the provision of SPA, so what's wrong with housing controller give extension of time? Is he not entitled to exercise the power under this particular regulation of 11(3)? Has granting of extension be exercised just a manner, or were the affected buyers according to the right to be heard since it affected them? So, Dr. Chang, I believe that you have written extensively on this issue. Perhaps you could also elaborate from here and give me some simple terms.
Well, I've elaborated just now about the nonsensical Housing Developers Regulation 11(3). Now, this section here is history already. It's history. It is now surpassed by the decision by Ang Meng Lee and others versus Menteri Perumahan dan Kerajaan Tempatan. The decision was made, reported in 2020-1 CLJ 162. The federal court decision was such that it was headed by our Chief Minister, Chief Justice of Malaysia, Tan Sri Tengku Maimun. She quoted, when she expunged this particular housing development regulation, she said that we hold that the controller has no power to waive or modify any provision in the Schedule H. Schedule H being a prescribed sale and purchase agreement. We subsequently hold the Regulation 11(3) of the Housing Development Regulation conferring power to the controller to waive or to modify of the sale and purchase agreement is ultra vires the act, meaning that the court, the federal court, the highest court in Malaysia, the apex court has ruled that this particular section is actually void. The minister got no power to pass to the minister, to the controller, who subsequently issued out the EOT. That's what it means. Now, our team of lawyers actually took up this matter here. Our team of lawyers, our HPA group of lawyers was headed by Yang Berbahagia Dato' Andy Wong, Mr. Albert Su, and Viola De Cruz. And the team of 8 lawyers, we all did volunteer work on a pro bono basis. Pro bono meaning free legal fees. We took up this matter down here because this particular section was abused by the minister, was abused by the controller housing. We had to make sure that public interest litigation shall survive. Take up this matter here on a pro bono basis so that more house buyers can understand what is this section 11(3) all about, what is this nonsensical EOT is all about. Now, this journey itself, this journey to win this case took us nearly about 3 years, 4 months. We started this case on the 9th of August 2016, went over to the Court of Appeal on the 31st of March 2018, And finally, we landed at the federal court on the 26th of November, 2019. It is to us a victory to the house buyers. Now, there's one thing I need to highlight very importantly. Why is this EOT so important over to the general public? Now, do you not know, be mindful, there are now 536 EOTs around. 536 EOTs around that have been approved during the span of the last 6.5 years, from the year 2014 until July 2019. We have got this statistics from the current parliamentary sitting. We have got it in the Parliament Handset that this was granted by the Controller of Housing under Regulation 11.3 and by the Minister under Housing Development Regulation 12 since the year 2014. Now, you as readers, you as listeners who surf the internet for those names of those housing ministers in office during that period of time, why were such whopping 536 EOTs issued to developers? Why was it issued? But prior to 2014, the ministers were more kinder. There was a rarity. It was hardly issued at all. That is why to us, this EOD thing won at the federal court, it's a precedented win. Nearly 500,000 of house buyers has benefited from our pro bono action. Keputusan ini memang merupakan kemenangan besar buat pemilik rumah di Malaysia. Terima kasih.
Thank you, Dato'. But okay, Dato' was talking about has been stated in the federal court saying that on it is not right to use the section 2.2. But our last week webinar is also proposed a countermeasure for the minister to granting the EOT to developer under section 2.2 Housing Development Act 1966. So they recommended that in the absence of Housing Development Regulation 11.3 being declared ultra vires, the Minister of Housing can still exercise the power conferred upon her to under Section 2.2 the Housing Development Act, exercise the discretion conferred upon the Minister of KPKT by granting the EOT to developer affected by the pandemic under Section 2.2 of the Housing Development Act. The period of extension should not only be for MCO period, but such that protect the housing developers and purchasers. What is the HBA view on this? Perhaps later on we can also have Dr. Roger Tan on the view on Bar Council on this manner.
Well, my view is that using Section 2.2 of the Housing Development Act is nonsensical argument. Why I say that is that now it is clear in Section 2.2, it merely empowers the minister to exempt developers from the application or provision of the Housing Development Act. Like for instance, I give an example, exemption. The current law is that to get the developer's APDL, you must be 3%. Developers must pay 3% of the gross construction cost for a developer license. Like for instance, the project is say 200 million. It equates 3% means $6 million got to be deposit sebagai cagaran kepada Kementerian Perumahan Kerajaan Tempatan as a deposit. But the minister has got this power under Section 2.2 to exempt the developer to pay the cagaran of $6 million because the old rate being 200,000. Now I've checked the handsets, I read through the handsets, why the minister granted exemption under Section 2.2. It is because, according to her argument, is that they are small GLCs. They are small-time developers in outstation, in Kota Baru or in Perlis who wants to do development work. That's why the government granted an exemption under Section 2.2 to only ask them to pay the pittance of $200,000. That is the minister's power under Section 2.2. But to use 2.2 to do an EOT thing, it is a flawed argument. Hence, to us, Section 2.2 is an exemption granted to, inverted commas, housing licensed housing developer, an exemption of the provision of the Mother Act, that's Housing Development Act. Now, be mindful, once a sale and purchase agreement is formalized, the minister cannot purport to reopen a signed contract and amend under the pretext of exemption of the provision of the Housing Development Act. So therefore, the argument to use Section 2.2 is flawed. Now, some lawyers even they went to the extreme because they want to be in the good books of developers, even recommended that the minister use Section 12 of the Housing Development Act. Similarly, Section 12 is merely a direction to a housing developer that cannot alter existing legal contracts or in the sale and purchase agreement. The power of the minister is over the licensed housing developer as of Section 12 and not over buyers who have existing contractual rights pursuant to the sale and purchase agreement. Therefore, even using Section 12 is also wrong. Now, be mindful that Section 2.2 cannot be exercised to modify, to change the subsidiary legislation, i.e. the gazetted standard sale and purchase agreement, which have been executed by parties before the MCO, before the movement control order. Now, for a formalized sale and purchase agreement, the operations of the section can be argued to be capable of altering the existing contractual rights of a buyer. Now, once a standard sale and purchase agreement has been executed, unilateral and retrospective modification of the content of the SMP is not permitted. It is not permissible except with the consent from the purchaser vis-a-vis rights to be heard. Now, this is the case that was cited and it was presided over by Chief Justice of Sabah and Sarawak, Yang Arif, Tan Sri Dato David Wong. Now, he mentioned, very importantly, the rights to be heard. In this respect, we note that purpose of this act was to protect the interests of purchaser, as the rights of purchaser to claim damages in the event of delay would be adversely affected or even extinguished. We hence agree that the purchaser, must be given an opportunity to be heard prior to any decision made. That's what is distinctively stated. I will also take you to other cited cases. Next case. Next slide, please. Now, in the case of Sentul Raya, let me get my slides back first. In the case of Sentul Raya Sendram Berhad versus Hariram Jayaram, the Court of Appeal, chaired by Justice Yang Arif Gopal Sriram, mentioned that the sale and purchase agreement is a prescribed form and regulated by status, regulated by statute. Okay, this is a slide. Okay, Mr. Moderator, this is a slide.
Okay, yeah, this is Sentul Raya versus Haram, and this is City Investment.
Yeah, the next case, the case on Sentul Raya basically mentioned parties to a contract in Form H cannot contract out of the schedule form. In this case of City Investments and Berhad versus Koperasi Serbaguna QPAC, the court mentioned, the federal court mentioned that the protection afforded by this legislation to house buyers is not merely a private right, but a matter of public interest, which Parliament has intended to protect from being bargained away or renounced. The next slide, basically, what's the preamblum of this housing development Control and Licensing Act. It my other slide.
We lost you.
Preamblum, housing development. Next slide.
Yep. Okay. This one, yes.
Next one, please.
This is, yeah, preamble.
Okay, this one here. The preamble of the Housing Development Act. Don't forget, the Act says is to provide for the control licensing developer and protection of interest of purchaser and for matters connected thereto. What does it mean? It basically means that Section 2.2 of the HDA to modify is not the way forward. It's not a question of exemption. We are talking about a case of midstream construction, mind you. Now, but the way forward, the way I see it, is that, in our opinion, for existing sale and purchase agreement, there may be, I just say just maybe, a possible argument for a new set of regulations under Section 24, bracket 2, bracket E, as a temporary relief, strictly as a temporary relief for this MCO period, that time be suspended during this lockdown infested by this COVID-19 epidemic. Perhaps I would even call it reasonably an extension of an injury time. Perhaps even to expand further, let's also expound Section 24, bracket 2, bracket IA. But I use the word strictly. Strictly meaning basically, let's do it for a temporary basis only. Do not do it disproportionately. Meaning, do not overextend a certain this extension just because the MCO is there. Okay, a reasonable time frame is our calling. Now, I suggest that the minister gets all his legal brains together, ponder over this section that I've just quoted. If you make a mistake or act a modified, HB will be keeping an eye on it after all. But however, at the end of the day, very importantly, is that the best option to address all this problem overall, holistically, is a legal shield for contracts in COVID-19 Relief Measures Act 2020 to avoid any possible room for disputes and legal entanglement. It is very importantly that we must stand-alone act to protect all contracts in the market. Thank you.
Thank you.
Back to you.
Yang berbahagia Dato' Chan Kim Long. Thank you so much. Thank you. Thank you for all the explanation on the importance on every single act and regulation and how it is affected both pertinently is on the order interest on the purchase the house buyer, as well as in terms of how to protect our existing legal framework. And when we talk about legal, I must invite our next panel, not other than Yang Berbahagia Datuk Roger Tan. Just let me give a small introduction of Datuk Roger Tan. Datuk Roger is the founder and managing partner of Roger Tan and Partners. He has acted for various corporations and institutions in Malaysia, Singapore, and Hong Kong as a legal consultant to various statutory bodies and government authorities in Malaysia. He sat in the legislative drafting committees of Johor State Government and Federal Ministry of Housing and Local Government with regards to Water Supply Enactment 1993 of Johor, Water Supply Successor Company Enactment 1993 of Johor, Housing Developers Control and Licensing Amendment Act 2002, and its regulation, Housing Development Controlling and License Amendment Act 2007, and its regulation, and the Solid Waste and Public Cleansing Management Act 2007. Dato' Roger was an elected member from 2004 to 2009 of the Bar Council of Malaysia, the governing body of Malaysian Bar. In March 2018, he returned to Bar Council and continued to serve as one of the elected members until March 2021. He is currently appointed as the chairman of Conveyancing Practice Committee of Bar Council of Malaysia. On July 1st, 2015, He was appointed as the president of Strata Management Tribunal when the new Strata Management Act 2013 came into force on the same day. Since early 1980s, Dato' Roger has been writing regularly, and he has contributed many articles and local foreign legal periodicals and news media, including Asia Week, Far Eastern Economic Review, Malayan Law Journal, and Current Law journals. He has also written for New Straits Times, The Star, and The Sun newspaper. His current column in the Sunday Star is known as With All Due Respect. Let's welcome Yang Berbahagia, Dato' Roger Tan. Dato', good morning to you.
Thank you, Haji Samso. First of all, I don't remember sending this CV to you. You must have got it from my website. All I wanted, an introduction was a simple one to say that I'm a senior lawyer. That's all. Because whatever I'm going to say today, I need to make a disclaimer. That is, my views are not representative of the Bar Council, as well as the Strata Management Tribunal. But between HBA and Radar, I will remain as a neutral party. Both of them are my friends. And in fact, this MCO and the COVID-19 has united both of them. Both parties are calling for a legal shield because they have brought different consequences to the parties, be it a purchaser as well as a developer. So let me start. In fact, I wrote an article. Can I have the slides, please? Okay, I did write an article on the 6th of April in the Star, where I argued that Malaysia does need a COVID-19 bill. You can log on to the Star online and see my arguments. Next slide. In fact, several countries have already done it. As you can see on the screen, Singapore has done it by way of the COVID-19 Temporary Measures Act 2020, the UK Coronavirus Act 2020, the Australian Coronavirus Economic Response Package Omnibus Act 2020, the Emergency Measures in the Public Interest COVID-19 Act 2020 of Ireland. Scotland has done it as well. And in fact, Hungary has passed the Containment of the Coronavirus Act 12 of 2020. Now, of all these legislations, perhaps Singapore's COVID-19 Temporary Measures Act is most comprehensive. It was passed in one single day on the 7th of April and assented to by the President on the same day. Excuse me. The Act applies retrospectively, and it has come into force in stages since the 27th of March this year. Now, the salient provisions of the Singapore Act, next slide, it provides temporary reliefs on actions for inability to perform contracts listed in the schedule of the Act. So only certain contracts are protected, and these contracts are set out in the schedule to the Act. And only contracts that are signed on or after 25th March, they are afforded protection. So what happened is that the Act will allow a statutory suspension of contractual obligations under these contracts. That means that if the relief is given, it will be an offense for any individual or organization to take action against the defaulting party. Then they have the temporary reliefs for financially distressed individuals, firms, and other businesses. This is where, for example, they increase the threshold of the for insolvency actions. The amount that the debt must be of certain amount before you can file a bankruptcy action or a winding up action against the parties. There will be no receivership during this period, no repossession of goods. All proceedings are stayed. And also the Act will allow the extension of the limitation period. Those lawyers will understand that there is a limitation period for you to file actions. And what happens if this period expires during the MCO? You cannot revive it unless you have a COVID-19 Act like Singapore.
Yep.
And you have the temporary measures for conduct of meetings by prescribing alternative arrangements of meetings. The Singapore Act says that in respect of any law that deals with conduct of meetings, they are allowed to use alternative arrangements, such as video conferencing. The same goes for video conferencing, proceedings on camera in the court as well as in the Sharia court. Next slide. So can Malaysia pass a COVID-19 bill? I understand we're going to have just a one-day parliamentary sitting on May the 18th. Well, I believe that there are some YBs watching our webinar today. So I just want the YBs to know that Malaysians do hope that for once you people will put aside your differences and do something for the rakyat by passing the bipartisan COVID-19 bill. Like Dato' Chan said, it will be a legal shield. It will suspend the enforcement of breach of contractual obligations. It will provide a much needed lifeline for many to survive post MCO. And also, apart from saving many SMEs, you can also save lives by not causing any suicide to take place. So the government and the politicians will have to have their political view and do it. Assuming if they have none, and they still masih gaduh lagi, then we have to work within the existing legal framework. And that will be on a piecemeal basis. So you are probably aware that the Minister of Domestic Trade and Consumer, being the minister responsible for the operation of the Companies Act, has made several orders as well as directions. So now the time for you to respond to a notice, statutory notice, has been increased from 21 days to 6 months. And also the threshold amount for winding up has been increased to 50,000 from 10,000. Now, in our case, the two main laws that govern stratified properties are the Housing Development Control and Licensing Act. I'll call it Act 118, and the other being the Strata Management Act 2013. I'll call it Act 757. Now, next slide. For the benefit of our listeners who are not legally trained, stratified properties can be residential or commercial. If it is a housing accommodation, then Act 118 will apply. If Act 118 applies, then you must use the prescribed contract, the contract that is prescribed under the law. That is the Schedule H. Act 757 applies to both residential as well as commercial properties. As you are aware, the current Schedule H has no provision to deal with an event of force majeure. And Clause 9 of Schedule H actually says that time shall be the essence of the contract in relation to all provisions of the agreement. So we still have to fall back on the express provisions of Schedule H. Now, what about those commercial properties, stratified properties? You will then have to look at the terms of those contracts. They vary from one to another. because they are not governed by law. So if you look at some of the contracts, they are often one-sided in favor of the seller. And it will contain some of these clauses. For example, it will provide for an extension of time if there is a delay, such as due to inclement weather. It will provide for force majeure, and those clauses will usually say that the seller will not be liable for any delay in the event of force majeure. And it will also provide for a situation of termination, often one-sided in favor of the vendor, simply because there is no law governing the contractual arrangements of these commercial properties. If that is the case, the only way for commercial properties, the buyers will be by way of getting the agreement amended. And agreement can only be amended if both the parties agree. Now let me look at the next slide, which is what are the possible consequences? Excuse me. The consequences in Schedule H that may occur during the MCO because of the prohibitions made under Act 342. Now, in respect of the purchasers, if they can't pay on time during the MCO period, not being able to get the necessary financial assistance, there will be late payment charges. It will continue to accrue. And if vacant possession has already been delivered, then the time for the purchasers to lodge a complaint against any defects or shrinkages will be triggered. If the 24 months is up during the MCO period, then the solicitors will be required to release the last 5% of the stakeholders' money. And there will be, I watched the webinar, the last webinar, so some parts of it, and I want to refer to the part where it says that when MCO is in progress, you cannot go to the post office. Go to post office to post a letter. Developer is not able to render a bill. The buyer and developer is not able to give a notice to ask the buyer to take a vacant possession. I think that is not very accurate because postal services falls within communication. It is part of the essential services. Now we have MCO 1, MCO 2, when we have MCO 3. Each of these MCO, the government has improved on the regulations. Now, if you look at the regulations governing MCO 3 that will expire on 28th of April, it is very clear that anyone can procure essential services. That is what Regulation 4 says. You can move around and procure essential services, provided if the authorized officer stops you, you give the necessary proof. So you see, if you have stack of letters to go to the post office, you can. That is what Regulation 4 says. You can procure essential services. And this is a common sense approach, because solid waste management is also essential services. If you cannot leave your house to throw your rubbish at the nearest garbage bin, you can't be keeping waste inside your home. It doesn't make sense. So it's not quite accurate to say that. So you can go and post offices to post all those letters. Now, one comfort to the buyer under our Schedule H is, regardless of your default, it's not that easy for the developer to terminate the agreement. You still have a grace period, a total grace period of 60 days to remedy your default. Now, let me look at the consequences in respect of the housing developers. Next slide, yeah. Now, there is no force majeure clause, as I said, in the Schedule H. I won't be dealing with frustration. Frustration is governed under our Contracts Act. If frustration applies, you will bring the contract to an end. I don't think it is the intention of the parties to bring the contract to an end. The buyer still want a home. The seller still want to sell a whole house. They still want to continue with their obligations during this period. So we have to find a way. You have heard the strong words and objections from the Honorary Secretary General of the House Buyers Association against the use of Section 2.2 of the Housing Development Act. I should deal with that later. But without an extension of time given to the developer, they will have to pay LAD if vacant possession is not delivered on time. I also heard the argument that the developer can invoke Section 8A of Act 118. Section 8A of 118, Act 118, allows a buyer to terminate the sale and purchase agreement if the developer has delayed or suspended or ceased work for a continuous period of 6 months or more after the execution of the SPA. I think this is a bit far-fetched. Number one, for Section 8, capital A to apply, the controller must certify that this event has taken place. Number two, and it has to be a continuous period of 6 months. And I can tell you, if MCO is continuously renewed for the next 6 months, I think all of us will be dead economically. Next is Regulation 11.3. Dato' Chan has so well put what is the position of the law. In fact, he's as good as a lawyer. Yes, Regulation 11.3 has been declared null and void, and the minister cannot use this provision to modify the prescribed contract by granting an extension. So the next question is, can the minister go under Section 2.2 of the Act 118? Let's look at Section 2.2. Excuse me, next slide. Okay, Section 2, subsection 2 allow the minister to exempt any housing developer or housing accommodation from all or any provisions of this Act. Now, the Act here will mean regulations, will include regulations. And since Schedule H is part of the 1989 regulation, so that is part of the Act. It's called subsidiary legislation. And the minister has been asked to go under Section 2, subsection 2, to exempt the parties from the provisions of this Act. And then under section 24(2)(1)(a), it provides for any exemption from the operation of this act or such housing developer housing accommodation as the minister deems expedient, and prescribe the form, limitations, restrictions, or conditions of such exemption. Now, what concerns me is this. Number one, even if section 2(2) can apply, it only helps the housing developer. But what about the home buyers who have to pay late payment charges? Can they be exempted too? It seems to exempt any housing developer or housing accommodation. Probably they can argue that because of exempting housing accommodation, the buyer is equally protected. I think what we need is actually a bill that can suspend the time and also postpone the performance of an obligations of both the developer and the purchaser. I've been thinking aloud whether there could be any other solutions. So something came to my mind this morning. I do not know whether it will work. I know probably some officers on AGC are watching this as well. Officials from the Ministry of Housing as well. But what I want to say here is that whether you allow exemption or suspension, or you impose a temporary moratorium, you still have to deal with post-MCO. What happens next? Assuming the exemption is over, suspension is over, the contract is reinstated. The original terms will apply. The parties will still be in breach. And section 2, subsection 2 isn't so clear at all. And the federal court has made it very clear to the minister and to all parties that Act 11A is a social legislation. Unless there is an express provision to empower the minister to do it, you cannot do it. I'm afraid if any action is taken under section 2, subsection 2, it will only create more litigation and uncertainty among the buyers. So I've thought about it. I was actually thinking we can go under section 24 of the Act 118. Now, section 24 allows the minister to make regulations. Excuse me. Number one, under subsection 2C, it says that the minister can prescribe the form of contracts which shall be used by the licensed housing developer or purchaser, both as a condition of the grant of a license under this act or otherwise. And if that is the case, the minister can actually prescribe a supplemental agreement to the original sale purchase agreement and set out the terms. How do you deal with the delays? And you give extension of time. And then you amend the regulations to include contract of sale, to include a supplemental agreement as part of a contract of sale. I can understand the difficulties we proceed under this particular paragraph C, because parties must still sign the supplemental agreements. It may help lawyers may help to give some work to the lawyers. But what if they do not want to sign? Okay, you can then say, we have put in the regulation that it is an offense not to sign. But we know that there is hardly any prosecution under the Act. So it's difficult to compel the buyer and the developer to sign any supplemental agreement. But it can be done. You can still prescribe a supplemental agreement. The other form is under paragraph E. It says that the minister can make regulations to regulate and prohibit the conditions and terms of any contract between a licensed housing developer and his purchaser. Now, I don't know whether this will work, but in my opinion, I think this would be a preferred way. First, you can prohibit the conditions of the terms of contract in relation to late payment charges and LAD as a result of COVID-19. You can then regulate. You can actually say, or you call these regulations as housing development COVID-19 regulations. How do you deal with them? You will provide statutory force majeure clause. What I'm proposing and what I thought of it this morning, it may not be foolproof, I agree, but at least give some thought and see whether we can go around these existing regulations in the absence of a full COVID-19 bill. Of course, there will be people arguing that, can you really do that? Because the agreement has already been signed. If you do that, then it will apply retrospectively. I check out the law. If you look under the Interpretation Act, under Section 20, subsidiary legislation can be made retrospectively. That is what Section 20 of the Interpretation Act says. It needs further study, and I'm sure HPA radar can sit down and try to see whether we can work under these regulations for the benefit of both developers as well as buyers. Of course, the Bar Council, always being a neutral party, is more than pleased to afford our assistance. Finally, I just want to deal briefly with the issues related to management of stratified properties and their common facilities. This is an area I think the renowned surveyor Wong is a better person to deal with it, but I will just deal with them briefly. During the MCO period, we have heard calls from parcel owners asking for discount or a waiver of the charges. This, I think, I believe Surveyor Wong will deal with it. All I can say is that currently there is no express provision in Act 757 allowing it. So you can't do it. I think the most urgent problem during the MCO period is actually dealing with interleakage, interfloor leakage. I think there's going to be a big problem because the upper floor unit owner may not allow you to enter his premises to inspect or do rectification works on the ground that is in breach of the MCO regulations. And also, even if MCO is lifted, the rules on social distancing will probably continue to apply for some time. Now, so in the light of this, how do you deal with them? The only way, again, is to see whether you can amend the existing regulations. And of course, under Act 757, there are times stipulated for you to hold your AGM, your first AGM of JMB, and also first AGM of MC. What happens if this is not done? Of course, Section 18 and 57 provide for penalties for non-compliance. You can be either fined or you will be sentenced to imprisonment. But I'm not so worried because the Attorney General, being a public prosecutor, I do not think in all his wisdom he will prefer any charges under this section, because you cannot hold an AGM due to COVID-19. I think this is one example whereby justice can be tempered with mercy. And also, I think the rules also say that even if the AGM is held out of time, you will not affect the validity of the meeting. So I'm not too concerned with that. And then I think what is most urgent is to amend the regulations. Like the Singapore COVID-19 bill. Allow AGM, allow management committee meetings to be held by way of video conferencing. Currently, there is no express provision. How about we can insert it? Under the Companies Act 2016, listed issuers can actually host the AGM by way of video conferencing, unless prohibited by the constitution of the company. So we have to live with it, because I think this way of doing things is going to be what we call the new normal way of doing things after MCO. So regulations will have to be amended. Unlike regulations under Act 118, regulations under Act 757 can only be amended by the minister after consultation with the National Council for Local Government. Usually it is chaired by the DPM and attended by the chief ministers. So there will be some adjustments to that. So finally, are the existing laws adequate? My answer is, of course, no. Whether it is adequate or not, it will be tested in the courts. But we do need a comprehensive legal shield against breach of contractual obligation. I don't think using and solving the problem on a piecemeal basis is the answers, because there are just too many varied situations. A comprehensive legal shield is required in these extraordinary times. It will deal with known problems as well as problems that we may not have anticipated. So thank you, Mr. Moderator. That is the end of my presentation.
So much, thank you, Dato' Roger Tan. Looks like we will really need a comprehensive legal shield, so that both all the stakeholders, all the parties in the industry will have it to be served fairly and justly. Dato' Chang, I understand that you have also put some pressure on the government by writing an article published in various newspapers and online portals. One that appeared in Starbiz was titled "Legal Shield for Contracts," and another in the Sun Daily was titled "Implement Moratorium During MCO." So, Dato' Chang, what is your take on this?
Well, this MCO period, the coronavirus 19 has derailed the entire world, not just Malaysia. While our government has granted assistance packages, financial assistance packages in the form of economic stimulus package to contain, sustain, supplement, stabilize, resuscitate, and restart businesses in the ordinary sense. One relief that has been overlooked is the protection for the people. That's the legal issue that I'm talking about, to people and the businesses who have been unable to fulfill their contractual obligation due to the lockdown. It is now extended further. Now, contracts and agreements are nothing new to all of us. It is part and parcel of our life. However, the inability to perform or fulfill any contractual obligation under the MCO period, because lives and businesses have now come to the halt within the last 24 hours from the 17th of March. People need protection. Contracts need protection. Now, I give you an example of a sub-sale buyer, not buying from developer, buying a sub-sale. Somebody signs an agreement in January with a buyer to buy a certain property, $1 million, for instance. He's contractually is supposed to sign and pay off the balance purchase price by April, say for instance, by April. But he is locked down. He can't arrange the loan. But some bullying seller may choose a reason to forfeit the deposit, because the agreement in the S&P, in the sub-sale agreement, may not have a force majeure clause. Now, this is to the advantage of the seller, but to the advantage of the weaker party. We need to protect all contracts and the weaker party. Another example is like a wedding. Somebody books a wedding package in a hotel, supposed to get married. The couple is still together anyway. They supposed to get married in April, but because of this MCO lockdown, the hotel, without the force majeure clause, forfeit his booking fee of 50%. That is utterly unfair. Cases like those we need to protect, not only vis-a-vis housing only, but we are talking about all contracts across the board. We must give protection to the weaker party to make sure that the time freeze is in place, that the whole moratorium law must be there, so nobody loses out in this kind of instances. Now, even similarly in housing, assuming you get a vacant possession letter dated 1st of April, you are supposed to collect your vacant possession within 14 days, otherwise deemed to have collected. But you are unable to conduct your defects liability list. The listing on all the defects, you're not able to go because of the lockdown. So how is it that the house buyer is going to go over and inspect the property with a list of defects to submit over to developers? This must be correspondingly extended. It is very important. But hence, as of now, I've seen several developers already in town that are now giving a corresponding extension, whether the law is there or not there. Those responsible developers are actually giving out the extension. They say, well, the letter dated 1st of April should now be seen as if it's dated 1st of May, meaning that they will deem it as if it starts 1st of May, 14 days vacant possession, subsequently defects liability period of 24 months only starts from 1st of May. I mean, those are being responsible developer. Now, to overcome most of it, if not all adverse consequences caused by this COVID-19, we recommend now in this COVID bill a mandatory force majeure relief, temporary, which is intended so that all parties' contractual obligation will not be hampered at all, back to its normal self. Okay, but it is also very important in construction industry. Not only am I asking basically a corresponding extension, it is very important. In my article, I did mention about a reasonable extension for the market players. Now, I give an example of contractors. When they come into play, it's not easy to go back on track whatsoever unless the government give them injury time and a little bit extra time. Apart from the MCO lockdown of 2 months, they get a corresponding 2 months. But they need more time to pick up speed I call it the injury time. Now, developers, all the Tan Sris, all the Dato Sris, they walk the corridor of power. They are very coming with politicians. Everybody knows that. They can make friends very easily. Why would I be surprised? They get what they want. But I know one thing for sure. My rationale of getting this extended period, this injury time from contractors, is because come post MCO. First thing is, foreign workers may decide to return home out of fear, out of decline in our Malaysian ringgit and other uncertainties. Secondly, there's the risk of the supply chain being disrupted and not able to be re-established over the short term among suppliers of key building materials, equipment, rental, and imported items. Thirdly, there is also a problem over the health requirement, the safety requirement imposed by all the various ministries on that. Of course, there is this certification by government agencies that may not be forthcoming. I understand a crane to restart their engine requires certification from CIDB. If CIDB have but limited staff to come and certify cranes all that, how many projects can go ahead? Until now, despite the relax of this MCO for construction industry of G1 to G4 or G5 to G5 or G7, I still find not much of a construction in the market at all. These factors are reality. These are real. I would like to mention here a reasonable time frame so that those contractors, very importantly, will pick up and get back on their feet. That is very important to move the market. That is, but the time frame, the reasonable time frame, we leave it over to the government to decide what is a reasonable time frame. But they must be guided again with proper analysis, proper assessors who comes in and say, okay, what is a reasonable time frame for contractors to start work or to start a certain project? Vis-a-vis, it could be housing, it could be property development whatsoever. That's only fair. Thank you. Back to you, Mr. Moderator.
Thank you, Dr. Chang, on the explanation on HPA point of view on this proposed a new Malaysian COVID-19 bill. And definitely, like you mentioned clearly, I totally agree. I think every single party will need protection and to be justice and to be fair. Next, let's welcome our next panelist, Surveyor Wong Kok Soo. Sir Wong is a consultant and a practitioner of professional property management practice. He is a fellow of RISM, PEPS, and MIPFM, and a former board member of the Board of Valuers, Appraisers, Estate Agents, and Property Managers. Sir Wong is the Managing Director of Burgess Rawson Management Sdn Bhd, a niche market professional property management and consultancy firm in Klang Valley with special focus on integrated mixed-use strata development areas. Surveyor Wong was actively involved in the drafting committees of Malaysian Property Management Practice Standards 2011, the Strata Management Act 2013, the Standard Formula for Allocated Share Unit and Share Units, and the Strata Management Regulation 2015. Surveyor Wong was instrumental in 2019 to successfully form the first and only subsidiary management corporation to date in Malaysia. Welcome, Surveyor Wong Kok Soo. Good morning to you.
Good morning, Tuan Haji Aman.
Good morning. Okay. Surveyor Wong, okay, for the current situation on MCO, everybody are staying at home, but especially for the stratified properties, all the parcel unit owner are still need to be paying charges, paying the single funds. Perhaps some also are facing the late payment interest, and also at the same time they will need to be effectively minimum manpower and also comply with protocol for COVID-19. So, should a management body of developer, JMB, MC, or SMC waive or reduce the monthly charges and late payment interest during the MCO period? And what are your views in terms of to hold the AGM or EGM online or virtually? So, over to you.
All right, thank you. Firstly, we got to understand what is a management body. When the purchaser receives the key, the developer manage it for about a year. That is called the management period by developer. So developer is also a management body. Then after that is hand over to management by joint management body. That is a temporary caretaker body that includes the developer. Then ultimately it is handed over to the final body, that is the management corporation. Then later on, some management corporation in integrated mixed-use development may create their children called the subsidiary management corporation. So these are the management body that we are talking about. All these management body, they are a creature of the Strata Management Act itself. So they can only act based on the powers and provisions that are conferred to them by the Strata Management Act. Reference is to the famous Rajawali case, right? So basically, they have to act within the provisions of law under the Strata Management Act. But there's no provision in the Strata Management Act to waive monthly charges and late payment interest. And hence, as mentioned earlier by Dato' Roger, the monthly charges, sinking fund, late payment interest cannot be waived. But you please bear in mind, what are these monthly charges? These monthly charges is basically is derived or determined from an operating budget, where the income is estimated just sufficient to meet the operating expenditure required to manage and maintain a strata building. So basically, you cannot waive these money charges. If you waive these money charges, how can the management body pay all these recurring monthly operating expenses, such as the electricity bill, water bill, IWK bill, and all the service provider invoices for the security guards, for the cleaners, for lift maintenance, and many others. Next slide. However, the Strata Management Act, although there is no provision to waive, but there is provision to reduce the rate of monthly charges and late payment interest. Late payment interest, of course, maximum is 10%. You can reduce it only by passing ordinary resolution in an AGM or an EGM. But we please bear in mind that during the MCO period, all the M&E facilities, although we say all the pumps are working, right? The suction tank pumps, the water pumps are all working. All the lifts are working. All the electrical installation and plants are all functioning. And even if we say the swimming pool cannot be used, but the swimming pool maintenance is still on, the pumps are still working. Because if we shut down the pool for 1 month, 2 months, and then it is full of algae, the whole pool will turn green. And then you have to, the cost of rehabilitating that swimming pool will be very expensive. All the lightings are on, the building services are still in operation, securities are there. And as MCO proceeds, a lot of people will be out of jobs. And in Penang, there is already a case of cat burglar. They're trying to go inside the condominium to break in and steal monies. So you need security. You need cleaners. Cleaners are important during the MCO period because they help you to clean and sanitize the common property in order to keep all the residents safe between the strata buildings. So whatever little savings that you can save during the MCO period, maybe it's a saving due to reduce frequency of use of the lift. People are in their homes, they don't come out often, so they seldom use the lift. There will be little saving, but you will have additional expenses for daily disinfection of the common areas with all those commercial grade disinfectants. You need also the cleaners needs to have this PPE, personal protection equipment. They need to have gloves, they need to have face masks, they need to have apron in order to help you to disinfect and sanitize common areas in the common property. And also you require hand sanitizers to be provided at the security guard house and the checkpoints, main lift lobbies, the lift cars. All this is for what purpose? It is to safeguard the strata communities against infection by COVID-19 virus. If you don't do that, then you have COVID-19 infection in the strata buildings. So whatever little savings that you can save during the MCO period, this can be used for these additional expenses. So the question is that there are requests to reduce the maintenance charges. But if you do not have surplus funds in the maintenance account, how do you reduce? You cannot reduce, right? But in some of the management body, they have surplus fund in the maintenance account. Then they can use this surplus fund to reduce the monthly charges. Otherwise, it's not prudent to do so. Even if you want to reduce, an AGM or EGM have to be held. But during MCO, you cannot hold AGM or EGM. Why? Because this AGM or EGM is a gathering of people, right? Even after the MCO is lifted, let's say after the Hari Raya, perhaps it will be extended after the Hari Raya. But this social distancing will still continue until there is a vaccine for the COVID-19. And for this vaccine to be a reality, it will be probably in 12 to 18 months' time. So it will be a long haul. Next slide, please. However, in the third schedule of the Strata Management Regulations 2015, there is a bylaw 6, sub 6, that allow for installment payment. So the management body on a case-by-case basis can consider and enter into suitable installment payment scheme with a defaulter who is badly affected financially by the MCO. Please bear in mind that this is only a deferment of payment, but it still attracts late payment interest on the outstanding balance amount. As I mentioned earlier, the budget, the charges are determined for a budget that is just sufficient to meet the operating expenses. So be very careful with this installment payment. If majority of them are for installment payment, then it will be very difficult to manage because of poor cash flow. Because cash flow is the lifeblood of any strata management scheme. The majority of owners do not pay up due to MCO or otherwise, the cash flow will seriously will be affected to the extent of building services, maintenance and facilities will come to a halt. If this is prolonged, the cost of rehabilitation will be very high. Next, please. There are some good suggestions to the KPKT minister to consider. In the Strata Management Act, there's a section 150, where the minister may consider to approve and gazette regulations that are applicable during and post MCO, as long as there is a need for social distancing until the vaccine for COVID-19 virus is found. So what are these proposals? The first suggestion is update and make all the relevant KPKT guidelines in its FAQ into regulations for this MCO period so that they will have the force of law for implementation and enforcement. Excuse me. And B, the management committee needs to make decision during this MCO period or post-MCO period. So committee meetings of management body, like joint management body, management corporation, or subsidiary management corporation, can be conducted via video conferencing without any physical contact or gathering, where decisions and resolutions are made with records of names of the members making their votes, and on the condition that sufficient quorum must be present when the votes are taken. So by video conferencing is very simple. When you want to pass a vote within the committee meeting, everybody knows everybody in the committee. Minimum is 3, maximum is 14 members, right? So all you need to do is announce the name and what is your vote, then you record it down and make sure that there is sufficient quorum. It's very easy for video conferencing. But when you use video conferencing for general meetings, AGM or EGM, and especially during the MCO, the numbers of attendees will be very huge, right? Small development, maybe 50 parcels, manageable. When you have big developments, about 1,500 to 2,000 owners. And at least 50% out of 2,000 will turn out we got 1,000 attendees. So when you have this, it will be very difficult to manage your general meeting. But what is most important is that when the votes are cast by the attendees, the votes have to be ensured that the votes are valid and the votes can be verified. So if the votes, such voting process can become very contentious if the validity of the votes is in question. So I believe serious thoughts needs to be given on such matter. So it will be good if the KPKT can engage these professional management bodies, which is the PAMS, the MIPFM, the RSM, and the MIPAC, MIPIC, and also the IT experts with regards to the how do you have voting process in a video conferencing so that the validity can be established and it will not be contentious. So also involve the Bar Council on point of law and HBA to protect the home buyer's interests. If they can have this discussion sooner as possible. Now the number of property management staff are required to work on site during the MCO. This has given rise to a lot of confusion because, excuse me, KPKT FAQ Bill 5 dated 8th of April 2020 came out and mentioned that there should not be more than 2 management personnel working at any one time in the Strata scheme, right? This gives rise to a lot of concerns and confusion in the industry because in my experience, the 2 management personnel working at any one time in the Strata scheme is suitable for a very small strata scheme of about 50 parcels, where in normal time, such small strata scheme already has only 2 staff. So MCO, no problem, 2 staff can actually go and operate, manage and maintain this small strata scheme. But in the large strata scheme, particularly in mixed-use strata scheme, their size will be around 1,000 to 2,000 parcels. Instead of 50 parcels, it's 1,000 to 2,000 parcels. In normal time, the staff force is 20 or more staff. So how can 2 management personnel cope with the management and maintenance work in such a big strata schemes? It gives rise to lots of problems in the first 2 weeks of MCO 1, MCO 2, right? Then luckily on the 13th of April 2020 onwards, MITI start to process applications and give operating approvals for additional sectors of SMEs to operate with 50% of the approved staff by MITI at any one time. So property management comes under the professional services related to the construction industry by MITI. Working at 50% of the total staff manpower at any one time will certainly meet the requirement for social distancing between the existing workspace. Assuming you have an office, a room, where you have 100% staff, you cut it down by 50%, you have plenty of social distancing workspace. So this will help to resolve the dilemma of insufficient workforce in the large strata schemes. But there's a problem. The MITI's processing of application takes time, right? Hundreds of applications went in, and they are very slow. Some of them have not received a reply, right? And it is not very clear, and some of them have filled up wrongly, I believe, and got rejected. So in the property management industry, is about 25% only have been approved. 75% is either waiting for a response or been rejected. So I think MITI should actually look into this better. Next, please. Another suggestions to the KPKT minister for the number of management personnel working at a strata building at any one time. The suggestion is to have at least 2 management personnel or 50% of the total number of property management personnel at any one time, whichever is the higher, in order to meet the need for operations for continuous and undisrupted essential services in each strata scheme. But there must be strict compliance to practice. Very important is social distancing, wearing of the face masks, as COVID-19 virus is known to be airborne. Have good hand hygiene. That means they frequently wash their hands or sanitize their hands with sanitizers of at least 70% alcohol content, and have good personal hygiene. Because a lot of these viruses, if they are found at the sole of the shoes, so they step over it, and after that they go home and they don't wash the bottom of the shoes with soap and water, they bring the virus back to the home. Daily temperature screening is important. So with this, it will allow flexibility to deploy this required workforce to appropriate duty rosters to be set up. And the other conditions that should be put in is that any of these personnel, management personnel, feeling unwell or has symptoms of fever, coughing, sore throat, respiratory problems, that means breathing difficulties, or certain loss of sense of smell or taste, must seek medical attention immediately and undergo COVID-19 screening if necessary as prescribed by the doctors, and also go on medical leave and undertake self-quarantine for 14 days. During these 14 days, they will keep a proper record of their health conditions, and if the symptoms surfaces, because the incubation period of COVID-19 virus is 14 days, is about 14 days, and if it surfaces, then they must go to hospital for treatment. Next, please.
Okay, thank you, Surveyor Wong. Okay, you're talking about all the steps, and some of the things, and especially the management staff and all these things. But when we in a strata scheme, we are all talking about the entire whole huge community. We have the parcel owner, we have the maintenance people and the management, and also the guard. So, what will be your recommendation in terms of the protocol in strata scheme to safeguard against the COVID-19? And handle is, if there is any COVID-19 cases, what will be the protocol to handle this?
Okay, next slide, please. Next slide, please. See, in every strata scheme, the strata community lives and works together within the same confined development. So it's very easy for this COVID-19 virus to spread and form clusters. If proper care is not given, it will form clusters like Mineral City 1 condominium under EMCO, Malayan Mansion, and Selangor Mansion. All the three are under EMCO. So it's important that there must be increased awareness and proper protective protocols to safeguard the communities in the strata schemes against COVID-19. What I mean by increased awareness is that the strata communities themselves must be aware that they need to have personal safety protection through social distancing. All right. Some of them were questioning why social distancing. We want to use the gym. So they questions the management body, why are they not allowed to use the gym? Why are they not allowed to have barbecue? Because they have barbecue pits in their condominium, right? Because all at home, after a while, they felt very bored, they need to come out. Okay. So social distancing is very important. Then they have to wear face masks if they come out from their home. They have to practice good hand hygiene, personal hygiene, and seek medical attention when feeling unwell, and also practice self-quarantine for 14 days if need to. Then the others is entry protocols are very important. If between the strata scheme, if there are no COVID-19 case, then they can consider themselves like a green area, and they must protect the green area. So they must have proper entry protocols with infrared temperature screening at the security guardhouse, checkpoints for both their residents who goes in and out, the occupiers, the service providers, the delivery men, domestic helpers, contractors, repairmen, and others, especially the delivery men. It is very, very important that they are not allowed into the building unless they clear the temperature screening. And if they are allowed into the building, it's only up to the guardhouse or the security checkpoint. They are not allowed to go inside the building to deliver their goods. And the next one is cleaning and disinfection protocols by cleaners is very, very important. Even before there is any COVID case, the common property needs to be sanitized. That means all the frequently touched surfaces of the common property needs to be sanitized on a daily basis. And when there is a COVID-19 case in the building, that sanitization frequency will increase. For example, normal times, you wipe all the lift buttons with disinfectants on a 2-hourly basis. When there is a COVID-19 case, it will increase to every 1-hour interval. Cleaners will be wiping the lift buttons, all right? Then you have emergency protocols to deal with COVID-19 cases. If there is a resident who says that they have been tested positive, so the management body and the management will know what to do. Ambulance will arrive at the building. You got to make sure that they come down by this particular lift, and the lift will be quarantined until it's disinfected. Then there will be deep cleaning, disinfections in the common property, and where there are residents. Sometimes this COVID-19 patient, for example, there's one particular case. The COVID-19 patient is a doctor. She lives with her family, a husband and a child. So she is found to be COVID-19 positive, but the husband and the child still stays in the apartment. And MOH requires the husband and the child to be quarantined. So if they are quarantined, which means that they cannot come out of the apartment, so they need food. So there must be food must be delivered to them. So there must be proper procedure to ensure that during the 14 days quarantine, they don't come out of the apartment. There's a supply of food to them, and you do not affect any other of the residents. All these details and of this protocol and all the important information can be found in the Burgess Rawson's internal staff guide and protocols for MCO and COVID-19. And this can be downloaded from the MPC PEMUDAH's Facebook or the Burgess Rawson's Facebook. All right. This is about 50 over pages, but it is very detailed and comprehensive. And this is the 5th revision because it has been revised 5 times because the Burgess Rawsons have 7 projects that have COVID cases. So after each case, then they will do a study and they need to revise this protocol, and they revise the protocol. So this is the 5th revision after 7 buildings came down with COVID-19 cases, right? But these are all high-end. They are not spread locally because people are, these high-end residents, they got money, they travel overseas, they come back from overseas, and these are all coming back from UK, coming back from US, where they are infected with COVID-19. Okay, next.
Okay. So, Surveyor Wong, you mentioned just now about the FAQ of KPKG, and I believe that they also have a few revision. The latest one, I believe, is stated on the 23rd of April. There's quite a few FAQ inside there. Perhaps we can also bring through some of the most important one for all the attendees and all the listeners.
Okay. This is a very long FAQ. So I just run through briefly, like AGM, EGM cannot be held during the MCO period. Everybody knows that. And then if inside a strata building, if you have laundry, maybe you have nurseries, or you have tuition centers, this cannot operate during the MCO period, right? And management office can be open during the MCO period. KPKT states down from 8 a.m. to 5 p.m. to manage and maintain the building services, facilities, and essential services, right? Although the management office is close to the public, but the management personnel will use it as the operating center. Okay. Although KPKT says that it should not be more than 2 persons at any one time, right? But this is already resolved by MITI's operating approval. Property manager, yes. Property manager is now recognized as essential service right now to manage and maintain the strata buildings, because if they don't go and maintain and there are disruption to the essential service like electricity breakdown, water supply breakdown, how can the residents stay at home? They cannot stay at home. It happened in Penang case where apartments, they have a burst water tank. All the residents got to come down and queue up for water at a water tank. Now, what are the steps that management, okay, when the management office is operating, those are the steps required by KPKT, letter authorization to all the staff. Right now, MITI has already given their MITI's operating permit, and with that permit, the management company will give letter authorization to the staff. And those are other preventive measures for the staff will be, they got to be practice social distancing, wear face masks, good hand hygiene, good personal hygiene, and so on and so forth. Okay. Can common facilities like hall, gymnasium, badminton court, swimming pool be rented out or be used during MCO? KPKT say no. Okay, next please. Can renovation work be carried out during MCO? So it's also no, because it will allow general workers to come in. Operation for critical services like water, electricity, security, cleaning, maintenance of the lift and pump system is yes, definitely is yes. Committee meeting take place during the MCO period. So KPKT says there will be no physical gathering, but they can do by way of teleconferencing, which is actually video conferencing. Next, please. Can the community move around in the strata scheme during the MCO period? KPKT says no, you cannot move around for residential scheme. Commercial scheme, all those companies, other essential services, they can still operate, they can still move around in the building, but reduce movement, as mentioned by KPKT. But now, when KPKT needs to update this, because MITI has come up with additional sectors that can operate during the MCO period. Next, please. This is a repetition of the earlier one, where the management office can still operate, but is shut down to the public. The management office is the operating center for the maintenance team. Sanitization contractors, yes, because if there is a COVID case, you need to fumigate certain areas. Visitors are allowed. KPKT said no, no visitors are not allowed because they don't need to protect the green area. So the only visitors that are allowed under special circumstances, one is senior citizen living alone and requires monitoring. So the only visitors that are allowed will be the children, immediate children or sibling or caregiver. Then the other one is that the occupant is a sick person, not COVID-19, it's just sick or infirm who needs regular monitoring. So the immediate children, sibling, or caregiver is allowed to visit the occupant. And the other one is the occupant that requires immediate medical intervention. And so the same, the children, the sibling, or the medical caregiver is allowed to enter the building. In the case of death, KPKT says only immediate children and sibling or undertaker allowed. No friends, no other visitors. Next, please. KPKT FAQ is actually in Bahasa, and this is English translation to the best of the ability and knowledge, right? So all those visitors earlier mentioned, they're allowed to enter. They must clear temperature screening. Any visitors whose temperature is 38 degrees Celsius and above will not be allowed to enter into the strata scheme. Now, the other question is Airbnb activities allowed? Short-term rental accommodation during MCO period. Airbnb means you introduce visitors into your building. Short-term, they are just like tourists. Short-term stay. Answer is no. Then the next one is the delivery personnel, like GrabFood, Foodpanda. They can deliver only up to the guardhouse, right? And then for postmen, they can enter into the mailbox room, which is usually on the ground floor. Next, please. Now, on this leaking pipe and short circuit, if there's a leaking pipe or short circuit in an apartment or in a parcel, can action be taken? KPKT say yes, you need to repair it, because if not, it will affect the everyday life of the occupants during the MCO period, which means that if it's a short circuit, you don't repair it, how can they stay at home? Next is, can occupants take part in outdoor activities like exercising, jogging in the compound of the strata scheme? KPKT say no, but a lot of people feel very, very uncomfortable. Those who have stayed after MCO week number, MCO 1, MCO 2, MCO 3, MCO 4, if the apartment is very small, they need to go out and exercise, right? But KPKT say you need to have social distancing, you stay at home. You cannot come out, right? There are a lot in the One Kiara. They went jogging between their big condos compound, and they got arrested. Okay, because some of the neighbors informed the police to come in, and they got themselves arrested.
Very cruel.
So whether you should allow, if they can actually be responsible, exercise, social distancing, maybe they can come out and exercise in the compound, but not in groups, in gatherings, small groups of people. But they should wear face masks. Maybe KPKT can look into this. Are business allowed to operate in commercial strata scheme? KPKT say only those under the category of essential services. But now things have changed. MITI has approved operating permits for other additional sectors, and this needs to be updated. Can shifting in and out be allowed? Answer is no. If your tenancy has expired, then the tenant must negotiate with the landlord to extend the tenancy until the MCO period ends. So these are basically KPKT guidelines. They are only guidelines. They do not have the force of law, right? So we can only appeal to those strata owners to be responsible, to know their responsibility, because If not, they can be infected with COVID-19, which is very contagious, all right? So they should try to understand and cooperate with KPKT. If not, enforcement. It doesn't have any force or law to enforce. So that's why in Mont Kiara, when it happens, the neighbor phoned the police came in under the Prevention and Control of Infectious Diseases Act and Police Act and arrest them. Right.
Okay.
Such cruel neighbors.
But I believe that it's all for the benefit for everybody, safety and health. Yeah, thank you, Surveyor Wong, for a very, very detailed explanation on all the do's and don'ts, what can be done, what cannot be done, and what are the steps and measurements that for everybody in terms of Surveyor Wong have covered in terms of the maintenance charges. You have covered in terms of the way how you hold the meetings, and even all the FAQ. Thank you, Surveyor Wong, for translating the entire whole FAQ from Bahasa Malaysia into English for all the attendants here. Dr. Chang, these are some of the questions have been answered by Surveyor Wong. Do you want to offer any further comment on this?
Yes, I am in, as usual, total agreement with Surveyor Wong Kok Soo. Now, he's a renowned speaker. His explanation are comprehensive and is excellent. But these good slides, we must not be selfish. We must learn to share these slides with all the listeners and permit to appeal over to the moderator and PEMUDAH and Dato NDCO to allow these slides to be made available free for the public so that the listeners can download, the surfers can download, at least, we share the information. Make it accessible in our this particular platform. Now it's okay with you.
Yes, on behalf of PEMUDAH, this particular slide will be made available to download after the session, and as well as the Surveyor Wong has shown two of the documents just now. One is the internal protocol, as well as this FAQ, the original version, which is in Bahasa Malaysia. It will also make available to download at their Facebook page.
I think that's fantastic. That's fantastic. Very well done. Good job.
Okay. All right. Just I understand that you have also putting some of their comments on their papers. This is from the Age Properties. Stay at home without affecting property management would be disastrous. Would you like to add some of the comment on this?
Well, this was an article done prior to the government not making property management as an essential service. But then that's water under bridge already. This article was to prompt the government. We got to do something about it. Hygiene, safety is crucial. But without property management, the JMC and MC to move, you cannot possibly get these things done. So, but it has now become a reality. I think it is fantastic. The government respond over to the call by the property managers, especially perhaps led by Surveyor Wong Kok Soo. But then there's one item that I need to bring up. It is basically on AGMs, virtual AGMs, EGMs, all that. Now, it has now become a norm to make sure that we in future have virtual AGMs, EGMs, and committee meetings, replacing the traditional meetings at a physical location, all that. Now, recently, I believe Security Commission has come out with the guidelines, their proposal about virtual meetings. Perhaps we can adopt some of those guidelines on there so that we don't have to we don't have to rehatch all over again. Thank you very much.
Thank you, Dr. Chang. Dato, I also understand that HBA has published a book on the stratified living title, HBA Insight into Strata Management Legislation. Would you like to offer us some insight of this particular publication?
Thank you, Mr. Moderator, sir, to allow me to do a little bit of advertising. It is for a good cause. It's for a little bit of fundraising for HBA. But not just only fundraising. Our motto has always been very important to disseminate information to the public. Now, this book, it's a very thorough book. We've done a lot of articles on this book here. It is basically a compilation of articles, numerous articles that we've done for the last 2 years that appeared in all the online as well as hard copy newspapers. Now, when the Strata management law was implemented, it dawned upon us that the legal language used in statutes are very difficult to understand. So, and very difficult to understand as well as comprehend. So running into hundreds of pages of the law, that we look upon it as though, okay, let's come up and do some layman's language. Now, we did a book that is layman's language, minus all the legal jargons, all that, so that even the ordinary folks could understand. Now, this book is published in English language, and the Selangor state government has agreed to translate it into Bahasa for us and at their own cost and funding. It is a very good book. You can email over to us. It's on the screen. It is sold at retail at $39.90. It consists of a lot of chapters. Chapters like topics like leakage, a living nightmare. Know the various types of resolutions under Strata Management Act. What are the differences between JMB, MC, RA, and your voting rights? Voting, your democratic rights under the Strata Management Act. If you want, just email over to us, notify us, and then as soon as this MCO lockdown is lifted, we see how you can pick it up from the HBA's office. Thank you, Mr. Moderator.
Thank you, Dr. Chang. Before I go into the open up for the question and answer session, I think recently I understand that HBA has also sent the letters to Jabatan Perumahan Negara KPKT for an answer on some of the sales and purchase agreement and during MCO and kind of things. But I understand that actually HBA are still waiting the response. Could you also please enlighten us on the updates on this, and what are the questions that actually HBA has highlighted to JPN?
Yep. Next slide. We have, in fact, on the 13th of April, 2020, written to the Ministry of Housing, seeking answers, pertinent problems, pertinent issues that house buyers are going to face during this MCO lockdown. First one, basically, there are about 12 questions. We are still waiting for answers, but knowing government departments, sometimes they walk slower than us. So it's okay, tolerable. Now, our questions like sale and purchase agreement signed, 10% deposit paid, letter of offer issued by the bank, MCO period imposed. Then the poor buyer lost his job, unable to proceed with the purchase. Buyer wished to opt out and seek a reasonable refund. Already the fellow has got no money already. He has got no job. He wants to get out of the S&P agreement. So developers cannot pester him to buy because he don't even now qualify for a loan. How do we help him? Second issue, sale and purchase agreement signed, progressive billing issued, housing loan legal documentation all completed, all finalized, but land office and high court not open because of MCO. Buyers now wish a waiver of interest beyond the 30 days period. So we are looking at corresponding extension of both parties if it's possible. Third question, SPA signed, 10% deposit and differential sum paid, housing loan documents signed pending release by bank, MCO period, lost source of income. He is a hawker. He can't operate at all, and now wish to opt out and seek a reasonable refund of the progressive payment they have been paying, not just the deposit, the more than the deposit they have been paying. Item number 4, SPA signed, vacant possession issued beyond the 36 months prescribed under Schedule H, notwithstanding the 48 months stated in the S&P, developer is late by 6 months. How is LAD going to be compensated? Next slide. SPA signed, vacant possession issued on the 17th of March 2020, 14 days deemed taken vacant possession, expired on 1st of April 2020. MCO lockdown until 28 April 2020, now extended, okay? Unable to inspect premises within the defects liability period of 24 months. the clock started ticking already from the 17th of March 2020, vacant possession date. Buyers not aggrieved by such an event. What about the buyer's corresponding extension? Question number 6. SPA signed, vacant possession issued on the 17th of March, unable to occupy subject property, yet must pay maintenance and sinking fund. In default of which, interest of 10% is going to be levied. Buyers feel aggrieved about it, cannot use, yet must pay. S&P signed, vacant possession taken on the 10th of March 2020 with list of defects given to a developer. Clause 30 of the S&P says 30 days notice expired, yet not repaired, and replacement not attended to under the MCO lockdown. Should we not have a two-way traffic down here? The next question, SPA signed and progress billing issued. However, due to MCO, not able to obtain loan approval and not unable to sign housing loan. Late payment interest to be waived with grace period to pay progress invoices since the buyer's purchase is on an ongoing project. Next slide. Defects liability period ended during MCO. Some purchasers may not be able to file the notice to rectify defects during MCO. Some developers insist that specific forms must be submitted by purchaser to claim benefits of defects liability period. Propose to enlarge the defects liability period correspondingly with the duration of MCO immediately after the lifting MCO. Stakeholder money should not also be released during the extended period. Next, buyers unable to pay the progress billing should not tantamount to default during the MCO period. Developers should not opt to determine or terminate the sale and purchase agreement. Number 11, deadline to file against decision of controller under Housing Development Regulation 12 should be extended accordingly. And finally, deadline to filing and serve defense and counterclaim and defense to counterclaim under tribunal by tribunal for house buyer's claim. MCO period should be excluded from calculation of deadlines. Similarly, deadlines of 30 days to set aside awards of tribunal pursuant to Regulation 26 of Housing Development Tribunal Regulation shall be extended accordingly if it falls within the duration of the MCO. Now, this letter we have written over to the Ministry of Housing. We have yet to get any reply whatsoever. We hope they will respond positively, looking into the rights, not just about developers, think about the house buyers' rights too. Thank you, Mr. Moderator.
Thank you so much. Thank you, Dr. Chang, and thank you, HBA, on all the effort to protect every single level of the house buyers in the countries. And thank you for all the efforts. So now let's go to our next session, which is our questions and answers. Perhaps let me start with one of the questions first. I have a developer had already obtained a CCC prior MCO, and they managed to send the notice of vacant possession during the MCO phase 2. Plus, okay, when I received the vacant possession notice, I supposed to collect the keys, but during MCO, I cannot go out. So what the developer did is, the developer solicitor has actually arranged Lala Move to deliver the full set of key to me. So my question is this VP valid? Yes, I know that I have received the key, but I would not able to stay at my property, as we are all in MCO phase 4 now, and 30-day dues date is coming to the end. Do I have to start paying maintenance fee and sinking funds as per the agreement? Any late payment interest will be imposed to me if I only make payment after MCO, which you don't know, I don't know, nobody knows exactly when will be MCO will be actually lifted. So how about DLP? Should it be started only after the MCO is fully lifted?
Perhaps we can get all the three panelists to have some word on this.
I think that is quite a mouthful. I think there are a few questions there. First one, if I can answer, is once the developer or solicitor has served the notice of delivery of vacant possession, the Schedule H is quite clear. It says that whether or not purchaser has actually entered into possession, you are deemed to have taken delivery of vacant possession. So the deeming provision, I'm afraid, will still apply within 30 days after service of the notice. Yeah. So if the deeming provision applies, then the buyer will have to start paying a fair and just proportion of the maintenance charges. Surveyor Wong. Yeah.
Yes, correct.
They will have to start paying, because this has to be fair, because the developer will have to bear all the maintenance charges prior to the delivery of vacant possession.
Right, we'll move on to the next question.
Okay, the next question, okay, this is from the ground. Okay, by law, high-rise buildings supposed to complete.
Yes. After the HBL case, which has brought to federal court, now developers change the SMP to 4 years of completion, which is against the act. But so far, nothing has been done to rectify it. In addition of giving themselves an extra year, if the developer apply based on the fact of MCO delay, is it reasonable?
Dr. Chan.
Yep. I couldn't get the question just now. I couldn't get a question.
Okay,
you read the question?
repeat again. Okay. By law, high-rise buildings supposed to complete within 3 years. After the HBL case, which has brought to federal court, now developers change the SPA to 4 years of completion, which is against the act. But so far, nothing has been done to rectify it. In addition of giving themselves an extra year, if the developer apply based on the fact of MCO delay, is this reasonable?
I see. First and foremost, it's not the HBA law, okay? It is the case done by the federal court under Ang Ming Lee versus Menteri Perumahan dan Kerajaan Tempatan. That's the case on the Ang Ming Lee's case, whereby it says any extension whatsoever beyond the prescribed 36 months is ultra virus. You now got to look into how was it extended? Was the letter of extension issued by the Controller Housing, or was it subsequently under Regulation 12 of the issued by the Minister? Secondly, if the SMP was previously 36, now changed for 48, something suspicious is there as to how it was changed into 48 months when originally it was 36. So my suggestion over to the complainant is, when MCO is lifted, HBA, we got our Meet the Public session on Saturdays. We have our free legal session on Saturdays. Come along, drop by HBA's office. We are very happy to look into the agreement. Bring a set of files. We'll be very happy to look at it, see how we can help the house buyers seek their legal rights.
Okay, based on the facts that are available, that extension, that unilateral extension, which the developer granted to themselves, is unlawful, because you did not follow the prescribed period as stated in the prescribed contract of sale. And also, the decision of the federal court in Ang Ming Lee has retrospective effect. So it will apply to all those previous sale and purchase agreements not extended, including those that have been extended. That extension are all deemed unlawful because they're ultra vires of the Act. I'm not citing anybody. I'm just giving my humble opinion on interpretation of how unmingly.
Thank you, Roger, for acknowledging the fact that this law on the Ang Ming Lee's case is actually retrospective effect. There have been some lawyers out there saying that, no, it's not retrospective, it's only prospective. No, it's not retrospective, it's only BHL construction case. They are so wrong. I agree with you, it is retrospective. Thank you.
Okay, to the best of my knowledge, any pronouncement by the federal court or the court of law can only be prospective if inside the judgment the judges actually discuss about the prospectivity of his decision. If you look at Ang Ming Lee's decision, the federal court, the Chief Justice did not say anything about prospectivity.
Yep, correct.
So it's very clear that it will have retrospective effect. Yeah.
Right. It basically ruled that Regulation 11.3 is ultra vires. Indirectly means if at initial. It means from the very beginning. Thank you. Let's move on. Next question.
Okay.
Panelists. Okay, this is the question from our faraway friends from Borneo. Is Sabah or Sarawak applying Housing Development Act 1966 or Act 116? If it is not, what regulation and guidelines should they refer on the cases related to today's topic?
I would suggest that Mr. Moderator, you invite my friend Roger Ching, the president of Sabah Law Society, to have another session, because whatever we discuss here only applies to transactions in Peninsular Malaysia.
Agreed.
Okay, thank you.
Questions. This extension of time for developers should also apply to contractors. Is there any talks between the relevant parties in order to have unified act so that all stakeholders are covered? And also, the argument against using section 24.2 is the schedule arrangement have already been entered into the developers and purchasers and terms cannot be changed. Dato Chang or Dato Roger?
Or maybe Surveyor Wong know some of these things is on this.
Well, construction, he's talking about construction agreement. Construction agreement has got three types. One, under PEM contract. Secondly, under JKR, Public Works contract, or the FIDIC contract. So his construction agreement is not under the purview of the Housing Development Act. So those construction contract, which I mentioned earlier, has got a force majeure clause. Read up the clause in there. What does it say? That's about it. Thank you.
Okay.
From the residents in Selangor mentioned actually. My question is to Yang Berbahagia Dato Chang. My aged mother has a property as Selangor mentioned, which is currently under MCO. Both these mentioned, Selangor and Malayan, is more than 50 years now. This is a flat under an agreement of lessee and loser by a realty company and imposed
not lessee, lessee and lessor.
Lessee and lessor. Okay. Lessee and lessor by a realty company and impose a forbidden charges on maintenance charges inclusive of sinking fund. There must be justice to all owners as these two flats has no facilities besides 2 passenger lift. On average, my mother has to pay approximately 400 ringgit per month and forced to pay for the entire year in advance. Once situation is back to normal, we, the flat owners, will seek the advice of Dato. What can Dato advise us now?
Well, the two things that I need to reply, first and foremost, now, when it comes to exorbitant maintenance charges, all that, please see our good friend, Dato Roger Tan. He's the president of the Strata Management Tribunal. That's one. Second issue, when it comes to Selangor Mansion and Malayan Mansion, I believe theirs was an old-fashioned SMP agreement signed in a form of a sale and purchase agreement attached with a copy of a lease agreement, renewable every 30 years. Now, these are the old-fashioned SMP agreement, before the National Land Code came into place. I'm very excited to look at their agreement. They should be fighting for strata title. I believe the developers there may not have applied for title because they think they are selling a lease. Or one, they think they're giving out on a lease. Lease meaning a long tenancy. I'm excited to see their agreements. So drop by HBA one of these Saturdays when we open. We have a look at it. Maintenance charges, go and see our good friend in Roger Tan. Thank you.
Well, I have to do a correction here. Come and see me doesn't mean come and see me physically. You can avail yourself to the Strata Management Tribunal by filing a claim to the tribunal. That's all. I won't proffer an opinion. Otherwise, you will bind my fellow brother and sister presidents of the tribunal.
No, you can't preside over this case because you have knowledge of it prior to you.
Yeah, now that you have mentioned me, I have to recuse myself.
Yeah.
Can I add in, if it is by lease agreement, it is not a subdivided building, they cannot even file a claim to Strata Management Tribunal.
Oh, it's not a subdivided building.
If it is under lease and if building has not been subdivided, but they should go and see the Dato' Chang at HBA headquarters when the MCO is lifted.
Let us verify the document first, whether it's in the form of SMP or a lease or a long tenancy agreement, all that. So whether they fall under the category of Strata Management Act or not to qualify themselves in the Strata Management Tribunal. Okay,
If
next
it's not
question.
a subdivided, you do not have a JMB and all that. Yeah.
Yep, correct. Agree.
Okay.
I bought an apartment 2 years ago and moved in immediately when I received my keys in December 2020. As MCO started in March 2020, I have a bad water leakage issue at my bathroom and kitchen area. Called the management, but they say they can't do anything now as no contractor is allowed to come in and fix the problem. And furthermore, they say it maybe is from the leakage is from the upper floor, and they can't even go in to verify this issue on the upper floor level. So the question is, what can I do now? Secondly, can I claim the damage of my furniture to the developer? Third, is my defect liability period will be automatically extended due to MCO?
I think Surveyor Wong will be a better person to answer this.
Actually, the KPKT FAQ guidelines, the latest guidelines, allow contractor to carry out repair works for such leakages. So they can actually go in, but this is during the developer DLP period. So the developer got to bring in his main con to do the job.
So
but the
DLP?
Surveyor, yeah. But those guidelines do not have force of law. So it's best that they actually make them into regulations.
I agree with you. That's why the suggestion is for KPKT to make those guidelines into regulations ASAP, as soon as possible.
What was the second part of the question, Mr. Moderator?
Can I claim the damage of my furniture to the developer? And how about the DLP? Will it be extended due to MCO?
That all depends. If it is due to the poor workmanship, the leakage is caused by the poor workmanship of the developer, then of course you can claim, yes.
And your view on the DLP will be?
there is no provision for any extension unless you have a law that allows an extension.
Yep, exactly.
All right. Okay. Okay. This is from another. This also pertaining to strata management. Okay. Since there is no express provision whether the AGM or EGM can be done via a video conferencing, can maintenance fee reduction or discount via a way of resolution to the owners or written agreement from all owners to allow maintenance fee reduction or discount for certain period of time? Survey Wong, would it be allowed, or in your opinion?
There's no provision in the Strata Management Act to for this AGM to reduce. You can't hold AGM during the MCO, so you cannot reduce.
Okay, all right. So this unless we are changing all the regulation, which I as from Dr. Roger explanation just now, even on changing regulation, we still the minister will still need to meet all the relevant stakeholder and to make a consult and make the changes accordingly, right?
That is made to consult the National Council for Local Government.
Yep.
Okay, all right. Okay, understood. Okay, this is the question for Dr. Chang. How do we address bullying purchaser? Would it be fair for a bullying purchaser, not bullying developer? This is how do we address a bullying purchaser? Would it be fair for a defaulting house buyer to seek maximum relief on one hand, yet unwilling to grant equivalent LAD to the developer on the other hand? Note that the contractor likely has ground to seek LAD from the developer. In long term, when no free lunch provided for future risk of MCO, developer maybe will price in the MCO risk in the future SPA. Future house buyer will have to pay more for it. Dr. Chang, have any comment on this?
First and foremost, I don't understand the question. Secondly, okay, on to bullying a purchaser. Now, this question surely must come from developer. They are saying that buyers bully them. If buyers bully them, don't sell. Very simple. Don't sell it over to them. You can identify who is bullying whom. That's about it only. As far as the agreement is concerned, assuming the bullying buyer, want to make their way around it, but yet the law doesn't allow it, then the developer should strictly enforce the sale and purchase agreement against the bullying purchaser. Follow your rights in a sale and purchase agreement. But I must qualify too, not all house buyers are angels. HBA do not fight blindly. We know who are the good ones. That is why in our HBA website, we all say, HBA free service for nice people only. You do not infuriate the very people who want to help you. You understand that area there? If you can comprehend, it basically means we can pick and choose who we want to help. Those bullying purchasers, we won't help. Thank you.
So you see, Dr. Chan is actually a very nice person, very kind-hearted as well. So what I want to say is that neither party in this case should bully the other or take advantage during this unfortunate time, because COVID-19 was most unforeseeable. So it is best that the developer and the buyers,
yes, agreed,
try to and sit down and come to an amicable settlement and try to resolve all those difficulties that they face as a result of COVID-19, because that will be in the mutual interest of the parties. Okay, for once I would say don't go to the lawyers. Sit down first, try to mediate and come to an agreement. Okay.
Okay, thank you, Dr. Roger. All right, this question to Surveyor Wong on the KPKT FAQ on strata scheme during MCO. Is it applied to both high-rise and landed strata? because let's say it is applied also for lender strata. One of the condition is not allowing for all the deliveries are only allowed to put at the guard house. And we all know some of the lender strata, some of the from the unit to the guard house is actually very, very far. So how do you, what is your advice on this?
Actually, you must understand the principles behind the KPKT guideline. The principle behind the KPKT guideline is that if the strata scheme has no COVID-19 cases, there's no infection, so it's considered like a green area. You have to protect the green area. So you allow the delivery persons to go inside the green area. Take for example, very good example is China. China has overcome their COVID-19. They lift up their lockdown. Then out of the blue, there's one girl who flew back from US, Chinese girl. Her hometown is Harbin. So she flew back to Harbin. She got no symptoms at all. So happily, she attended all the party gathering. Then before they know it, Harbin has 70 COVID-19 cases arising from one lady, right? So it's the same. How do you know the delivery person is asymptomatic COVID-19 carrier? So you allow him to go inside the green area, then eventually the green area will become red area. So basically, that's why they are at the guard house. And all those who stay in landed strata, they have their cars, they have their vehicles, they can come to the guard house and collect their food supply. If not, then they can make special arrangement with the security for security to send it to them to their doorsteps. All right?
Okay, thank you, Sir Wong. Okay, this is from typically a lawyer to a lawyer questions. Good afternoon. My name is Nisa from Tan Norizan Associates. I have a question for Dr. Roger Tan. I understand how COVID-19 temporary measure bill can protect purchaser and developer by postponing their obligation during MCO period. But how can the COVID-19 temporary measure bill protect both the purchaser and developer post MCO?
Well, if the COVID-19 bill, it is possible to enact the COVID-19 bill, then it must contain certain important provisions. One of it would be to incorporate a statutory clause of event of force majeure in all the agreements. And to deal with this event, how do you resolve it? How do parties deal with the breach of contractual obligations? And how can extension be given, both to the time for completion as well as time for the purchaser to pay all those late payment charges? The COVID-19 bill will also have to contain provision to allow a prescribed period, whereby during this period, no party is to take advantage of the defaulting party by taking that party to the court. Otherwise, it will become an offense. So you have to regulate. The government has to regulate. Otherwise, people will be made bankrupt. Companies will be wound up. Developers will run to Dato Chan for help, which is most unlikely.
Most unlikely. We must preempt the chain of confrontational litigation. Not in this time that we want fight. It's very important that fights must always be minimized during this MCO period. Okay, nobody got money now to pay lawyers. They want to have their own, by the necessity only pun cukup. Thank you.
Okay, it is almost 2 o'clock now. Let's look into the last final 2 questions, or a short one. Okay, assuming a purchaser purchase a property from the developer, signed the SPA, paid the deposits. However, developer has yet to execute the SPA due to MCO. Can the buyer opt to pull out from the transaction, citing reason the developer has yet to execute the agreement and to get back the full deposits? Is the act of paying the deposit to the developer lawyers amount to the emission on the obligation from the terms of SPA?
Roger, yours.
Yeah, so this is the question. Is the act of paying the deposit to the developer lawyers amount to an emission on the obligation of the term of SPA?
No, first of all, you're not supposed to collect anything before signing the SPA. That would be a breach of the regulations. I know buyers have been asked to sign a booking form, and then later on you will have disputes on calculation of LAD, whether it runs on the date of booking form or the date of SPA. But you must understand that the idea of having prescribed sale and purchase agreement, how did we come about it? That was those days in the 1960s, 1970s. We have all these abandoned projects. Developers were not regulated, and they came out with all sorts of one-sided agreements. That's where the government came in and prescribed all these agreements. No collection of payment before signing the SPA. So if you do that, I'm afraid you have committed an offense under the regulations. It is unlawful. So under the Contracts Act, anything that is done and the consideration is unlawful, then the contract is void. You're entitled to the returns of monies. I'm not giving any legal advice here. If you are in doubt, please seek independent legal advice. Okay. Thank you.
Dr. Chow, to add anything?
No, go ahead. I'm okay.
Okay. All right. Okay. So, okay, let's have the last questions. Okay. Okay. Dr. Chang did mention that perhaps can use the SC guideline to hold the EGM and AGM. Does it mean the HPA or other authorities will propose this to KPKT on this?
We are talking about virtual AGMs and EGMs, right?
Yes. Yes.
Yes. That's a proposal. I believe, Koksu, Hong Koksu, and our organization, we can work together to make this virtual AGMs a reality rather than the traditional having a physical location AGM.
Okay, unlike SC, we do not have those powers to do it. SC can regulate. And also under the Companies Act 2016, I think Section 237, it allows for holding of AGM via video conferencing, unless it is prohibited by the Constitution. Okay?
Correct.
Okay, all right. I think with that, ladies and gentlemen, we have come to the end of the session for today. I would like to inform to all the attendees and all the listeners that the presentation slides for today, as well as the FAQ KPKT and also Bugis Restaurant Management Internal Staff Guide and Protocols for MCO and COVID-19 will be uploaded into their PEMUDAH Facebook page later after the session. Once again, thank you Yang Berbahagia Datuk Dr. Engineer Andy Casio, Yang Berbahagia Datuk Chang Kim Long, Yang Berbahagia Datuk Roger Tan, and also Surveyor Wong Kok Soo for all your sharing session. Perhaps we can go one round on the closing with maybe start with Dr. Andy.
Thank you very much, ladies and gentlemen, for your patience, and also to our esteemed speakers for sharing their very well informed information. I'm sure that the individual association like yours will be putting out a paper to KPKT. The issues that have been surfaced and the solution that have been explored, we should put forward. KPKT is of course requested to take note of this immense challenge facing by the developer, housing developer, the house buyer, and also the property industry due to this pandemic of COVID-19 crisis and also the MCO period. Now, we also considered for speedy implementation of what we have discussed, immediate countermeasure that will be proposed or has been proposed also by PEMUDAH. During this period, we exercise some restraint and also accept some adjustment among ourselves. Here, we are trying to achieve a twofold goal. First, we would like to offer temporary reprieve for contracting parties who are impacted during the period. And secondly, to provide a platform for continuous economic activity, all right? Now, we anticipate the post-MCO and the COVID-19, there will be a period of adjustment to a new normal environment. A reasonable time is required for the market players to achieve back to their real activities. Now, with the threat of a looming global and local and a global recession, it is important for our country to focus on getting back on our economic bandwagon and also to enact a temporary legal shield, as explained by Dato' Chang of National House Buyer Association, in the form of a COVID-19 Act, also proposed by Dato' Roger Tan, to protect and allow businesses and even investors to continue their activities with confidence. Now, resources which are much slimmer now after the COVID-19 should be channeled to the right direction of economic regeneration. We should try to focus our strength rather than getting into a litigation, all right, which does not add any value. We will be wasting time and money, as both party, purchaser, house buyer, or property developer will be unnecessarily engaged in a legal battles. Now, with that, we believe that Malaysia has a very strong resilience to survive the MCO and also regains its status as a progressive and a dynamic powerhouse. With that, ladies and gentlemen, I also would like to bring to your attention that our next webinar series, which will be co-organized with MPC, is a sharing session on sharing Singapore's experience on the COVID-19. I would request this will be co-organized by the MPC GRP, Good Regulatory Practice Team. They will be organizing this somewhere in May the 5th. And hopefully, we also hope that we will be able to organize another session on this MPC PEMUDAH MPC session webinar. And this will be also hoping that we get KPKT, PEM, RADAR, and a few others to participate on a session on how to have a special SOP and online OSC during this period as well. As we know, we have all been, discussing this issue. The MCO might be extended. So with that, ladies and gentlemen, I would like to thank everybody for a good session that we have, and PEMUDAH will continue to organize a web seminar series for the Rakyat and also for the members. Thank you very much.
Thank you.
Thank you, Dato' Andy. Dato' Chang, would you like to have your closing?
Okay, thank you very much, Mr. Moderator. Very well controlled meeting. Now, my parting remarks will be, I hope that after this COVID-19 epidemic and our Mother Earth has gone through this renovation period in our Mother Nature's unprecedented way, we hope more housing developers will be more conscious, have conscience towards house buyers, rights and interests, and that because house buyers are their customers. When the developer wants to sell a property, they'll go all out to pacify a buyer and then subsequently entice them to sign the dotted lines. But then after that, they are merely statistics. Do not treat house buyers as statistics, you understand? They're not a number only. Buyers and property developers have to work together to make things happen. And in this current situation, you want a win-win position for all. No one party should have the upper hand, and I call it compromise. It is a concept of finding agreement through communication, through mutual acceptance of terms, varying from the original terms and conditions. We must preempt, like I said earlier, the chain of confrontational litigation. The industry's mire in a vicious cycle of litigation does not benefit anybody. Let's be pragmatic and focus on to ride over this current storm. Thank you.
Thank you, Dato' Chang. Dato' Roger, your parting remarks?
Well, just a short one. First of all, I'm indeed honored to speak together with the other two esteemed panelists. I cannot emphasize enough the importance of having this COVID-19 temporary measures bill, and I trust that PEMUDAH, led by Dato' Andy, will spearhead and will continue asking the government to do it. As a compromise, Mr. Moderator,
Yes.
I am looking forward to the lifting of the MCO so that I can invite Dato' Chan from the HPA and Dato' Suan from Reda to a nice meal.
But what's the catch? First off.
Okay, just listening to advice, I think at this time, both sides need each other more than ever. More than ever.
No, there are times when we see things eye to eye also. It's not that we don't see things eye to eye. There are common grounds that we can work together. Just don't be stubborn only lah. That's about it. Full stop.
So can you just end with some nice words rather?
Yeah.
Okay, thank you, Dr. Roger. Surveyor Wong, on to you.
A very short one. I just a closing remarks here is that KPKT should quickly look into coming out with regulations for MCO and post MCO with regards to the management of the stratified schemes and the safety of the strata communities. Right? And MITI should also speed up the applications and look into the processing those applications. Right now, it's only about 25% of the property management companies that apply have received their confirmation. So without MITI's approval and movement permit, it's very difficult to pass the roadblocks to reach their certified buildings. A lot of them have been asked to turn back and go home and to work from home. How do you work from home to manage and maintain a building? By remote control, like Dr. Roger says, interfloor leaking, you're using handphone, you please take some cotton buds and plug the hole. Right, thank you.
Okay. Again, thank you so much. As a moderator today, thank you for all the panelists. Thank you, Dr. for having us today. And again, thank you for all the three distinguished panelists for sharing with all the attendees, as well as in the on the Facebook, all the listeners. Everyone is saying it is a very, very informative session. Thank you very much. But before I ended today's session, let's continue to stay at home and stay safely, and most importantly, stay productive. Thank you, and hope to see you on the next PEMUDAH webinar series. Thank you so much.
Thank you.
Thank you.
Thank you.
Yeah.